you were to keep score for the first quarter of 2026, do you see a clear winner? 84% of all illicit crypto transactions in 2025 were stablecoins.
Where 70% of illicit stablecoin volume flows through less than 100 what they call professional money laundering services.
Last time I checked, there were 15 new charter applications. 11 of them had been approved. It's going crazy. Yeah, for every dollar that came into the bank, $2.77 of it went out to a stablecoin provider.
Office is full of captive employees who are effectively slaves that are being forced to engage in these pig butchering schemes and sending their crypto in the hands of ultimately North Korea.
The Munchee token in 2018, and then Meg Prime in January of 2026, they got a no action relief on something functionally extremely similar. How do both of these things that exist seemingly in the same universe?
Bring stablecoins into your strategy and make it to be regulated under Genius, because that is your long-term best bet right now.
Welcome to Fintech Confidential, bringing you the people, tech, and companies that change how you pay and get paid. You're building a fintech product. You want to offer digital assets, but wallets? That's the hard part. Security, compliance, key orchestration, blockchain integration. That's why fintechs, payment platforms, and custodians choose Dfns. They provide wallets as a service that's API first, multi-chain by design, and secured within PC. No single point of failure. So you can launch across over 50 blockchains, automate policy controls, and stay audit ready without managing private keys. Stripe's Bridge powers crypto payments through Dfns. MoonPay scales wallets securely with Dfns. Sphere grew without compromising on control or compliance. Even major FIs like Fidelity, ABN AMRO, as well as custodians like Zodia and Tungsten trust Dfns to power their on-chain infrastructure. Developer ready, compliance approved, production grade from day one. If you're building in payments, exchanges, OTC desks, market makers, or DeFi, Dfns wallets work the way you need them to. Request your demo at fintechconfidential.com/DFNS. Dfns, secure wallets built right. Welcome to Web3 with FTC, powered by Fintech Confidential. If you're asking how blockchain, crypto, AI, or even quantum computing fits into your business strategy, this is built for you. We talk with the builders and decision makers who are doing the work. And whether you're a founder, an executive, or just trying to stay ahead, this is for you. So let's go ahead and get started. I'm your host, Ted Huff, the CEO of Voalyre, a fintech advisory firm, and I'm here with the Fintech Confidential informant, Rob Musiala. He's a partner at Baker Hostetler, where he co-leads their Web3 practice, along with the blog, The Blockchain Monitor. And if you haven't yet, go ahead and check it out at the blockchainmonitor.com. Rob, welcome back. I mean, we've been collecting headlines all quarter from the Blockchain Monitor and a number of other different places. And we're going to go ahead and make sense of what Q1 of 2026 really has been through that regulatory lens of yours. The things we're going to be talking about is the OCC's 376-page Genius Act proposal, and why everyone from Wyoming to Paxos is racing for a trust charter. Not only that, we're going to unpack the SEC's new 5-bucket crypto guidance, including how a 1940s Orange Grove case study explains why ETH and XRP are now explicitly treated as commodities. And we'll even look into fresh AML data showing that stablecoins might be at the center of some illicit flows. What that means for the issuers and banks in Q2. Rob, from where you sit, is it fair to say that Q1 of 2026 has been the most substantive regulatory quarter in this industry that we've had yet? So, Rob, from where you're sitting, is it fair to say that the first quarter of 2026 is the most substantive regulatory quarter that this industry has seen yet?
I'm an attorney. I can debate anything, but that is absolutely a fair statement. It was a very, very busy quarter, really just between the OCC's Genius Act proposed rule, which essentially provided a wealth of practical details on how Genius will be implemented, and combining that with the SEC's interpretation on crypto assets, which is a landmark piece of guidance and guidance that the industry has been waiting for years. Between those two developments, and there's even more that we'll talk about, but between those alone, this was a major quarter from a regulatory perspective.
Let's start where the money is, right? Stablecoins, charters, and the Genius Act. Rob, the big headline the OCC published was basically this full stablecoin rulebook. And for that person who's watching or listening that doesn't want to go read those 376 pages, what did the OCC actually do?
The first thing to note is that, first of all, this is the primary proposed rule that will implement the Genius Act. But I want to note that there are several other proposed rules that have already been published and more that will be published by various agencies that will all be involved in Genius Act. That being said, this is going to be the primary one. And in plain English, this proposed rule is where the rubber meets the road in terms of bringing the Genius Act to a practical implementation. So the rule defines dozens of key terms. The most important of those terms is what's called a permitted payment stablecoin issuer, or a PPSI. And I would say,
dude, I gotta love the fact that we've added yet another acronym to our glossary.
And there are many, many more acronyms in the proposed rule, but the rule broadly sets forth the parameters on what a PPSI can do and what a PPSI can't do. And that will involve things like issuing and redeeming stablecoins, standards for audits, requirements for custody and safekeeping, the practical details of the application process. So how do you become a PPSA? How do you apply? How do you go through the registration and licensing? And then importantly, capital requirements for PPSIs.
The rule really got deep and set out the requirements around the reserves backing the stable coins. Help me understand, does this take us beyond what the Genius Act did, or did it just clarify it a little bit and like help us break that down of what the PPSIs will have to maintain?
The proposed rule, interestingly, stuck almost exactly to the language of the Act, the Genius Act itself. And so sticks with these very conservative categories. There are 8 categories. The first is US dollars. Second is demand deposits. Third, short-term treasury bills with a 93-day maturity. Then fourth and fifth, repos and reverse repos, both overnight maturity backed by short-term T-bills.
When I see tokenized cash equivalents, that piece there makes me start thinking we have these conversations about tokenized deposits and those types of items and other real world assets. And that starts to get me to feel like that's their little nudge, I guess you would say, towards something that might be in the future in that space.
I would expect that most of the reserves initially will be assets that are based off of short-term T-bills. Another important part of the Genius Act that bears repeating here is stablecoin issuers will not be allowed to commingle those reserve assets or rehypothecate them in any sort of way. And so, that is all designed, in my view, to create consumer trust in these stable coins.
You said it a number of times, short-term T-bills. And I think for the average person, and heck, even for people who've been in the space for a while, may not understand the reason for short-term T-bills. And correct me if I'm wrong, but it's really to be able to provide liquidity at a rapid pace if and when needed. What other benefits do you think this could provide for the PPSIs?
This is all about liquidity, and it's all about building consumer trust. And so that when a holder of stablecoins, even a holder of a large number of stablecoins, comes to the PPSI and says, I want to redeem these, I want my US dollars, that there'll be no issues in fulfilling those requests.
I'm curious from your perspective, what do you see as the single most important or practical consequence of the reserve language that has been placed in front of us?
Well, look, yeah, from a practical perspective, if you are a stablecoin issuer or you want to become a stablecoin issuer, there's now a lot of restrictions on how you can do that in compliance with Genius. And a lot of stablecoin issuers that are out there now that are holding their reserves in a lot of different assets will no longer be able to do that in compliance with Genius. So that means they're going to either have to change their business model, change their reserve, or they're going to have to make a deliberate decision to move offshore and service the markets outside the US. And that's a big decision point for any stablecoin issuer. And even the most conservative stablecoin issuers, may have to make adjustments to meet these very strict requirements on the reserve.
The T-bills piece of it, right? This, in my mind, I'm thinking Tether. Like they've got a huge gold reserve, and they've got corporate bonds, and they've got money markets, and they've got other, like you meant, like there's so many different ways. What are some of the things that will become a barrier of entry for them with their diversification that they have outside of that?
Well, I think Tether is sort of a case study in and of its own because they're so large and we have been operating for so long. But it's public knowledge that they do intend to launch their own stable coin that will be intended to comply with Genius. And the implication there is that they will continue to operate USDT as we all know it outside the US. So I think it's a little too early to tell if that is a strategy that other foreign-based stablecoin issuers might try to take. And there is a whole framework specifically targeted at foreign stablecoin issuers to be able to issue stablecoins in the US under Genius, which includes things like having to hold your reserves in a US bank, for example.
Stablecoins are meant to be looked at as low risk. They're not supposed to be a risky asset. They're supposed to function just like if someone were to hand you a $10 bill, it should function the exact same way. The risk is in the movement, not in the item itself, is really where I'm seeing it. And it really starts to feel like cash equivalent.
This is also intended to make stablecoins as simple as possible. So, you and I know, working in the digital asset space, the builders in this space are very creative. A stablecoin that is compliant with the Genius Act will be the simplest of digital assets on the marketplace, where it really does only do one thing, and that is give the holder either the right to redeem that dollar behind it, or the ability to transfer it to somebody else as a payment mechanism equivalent to the digital equivalent to cash, as you pointed out.
We're talking about how this starts to feel like a digital equivalent to cash and all these different pieces. And you talked about it has to be in a US bank. Now, where my brain goes is why is this why everyone is going for charters? Because we've seen a race for charters. I mean, just in the last few weeks, and I think I'm trying to keep up with it, because last time I checked, there were 15 new charter applications. 11 of them had been approved. From your perspective, because you see these things happening all the time, why do you believe we're seeing this flood of OCC trust charter applications come flying in right now?
Since like December of last year, so just in the past 4 months, let's say, at least 15, maybe more, of these OCC trust charter applications. My personal view is that this is absolutely related to the Genius Act. But what the trust charter does under the explicit language of Genius would open the door for those companies to become payment stablecoin issuers under the Genius Act.
I pulled this up on the screen just to kind of give everybody a feeling for the section. It's section number 11 here. Rob just went through it. Non-bank entity, uninsured national bank, federal branch approved by the OCC. I mean, it went great detail. And them setting out these rules wasn't wasn't random. Crypto companies, digital asset companies don't just want these charters because they're cool. They're really getting into position for when the music stops. I mean, if I pull up here, we've got what? Paxos received theirs. We've got BitGo. They received their approval. And I can't leave out our friends at Ripple. They also got approved as well. So there are a lot of things that have gone on in this space. I'm really want to better understand from you, how is this setting them up for when the music starts from your perspective?
If you have your OCC trust charter at the time that Genius goes into effect, and it will likely go into effect either later this year or beginning of next year, you are in position to immediately submit an application to become a PPSI, a permitted paying stablecoin issuer. As soon as those applications begin to be accepted and processed, and you are first in line. And will be other ways to achieve PPSI status, but the simplest and most straightforward is through the OCC trust charter path. And so I absolutely expect that all these 15 plus companies that have recently applied for OCC trust charters, that's the initial list of PPSI stablecoin issuers. You never know whether a company will look to issue a stablecoin right away. Some of the companies, by the way, already have stablecoins in the market, as you know.
It really points out like the operational advantages of getting inside of the banking frameworks early, so that as things are changing, it's not a wholesale flip over. I got to do something completely different. I've got to do something here, there. I'm curious, from a legal positioning, how does that benefit them from getting into this process earlier? Even just, let's just say, submitting an application. What does that do for me as a digital asset or crypto native company to even submit my application?
Well, I think one would be that the application gives a lot of detail on the business and what activities you intend to conduct under that trust charter. And so you can think about a scenario where the OCC has already approved a trust charter application. And then when it comes time for your PPSI application, a lot of that factual detail is almost exactly the same or is exactly the same. And also I'll point out, the current OCC is very friendly to the crypto market. We don't know what the next OCC administration will. We don't know if they'll be friendly, less friendly, more friendly, or neutral. But we know what we have now, and so I think that's part of what's creating this race, is to sort of take advantage of an environment where, by and large, the OCC has been friendly to these applicants.
As we're talking about this is really where I think the first quarter of 2026 really got fun, because as these charters are being issued, I'm just glad that no one brought a gun to a knife fight, but it definitely has felt like a knife fight between traditional banks and crypto native companies. And then they've both got a couple jabs in here and there. But if you were to keep score for the first quarter of 2026, do you see a clear winner?
I would say, you should talk about points. I'd say the first point probably went to the crypto industry, and that relates to the OCC trust charter applications that we were just talking about. Beginning in 2025 Q4, so last quarter, the bank sector saw these OCC trust charter applications. So they saw what was happening, and crypto native companies should not be allowed to undertake certain activities under quote fiduciary duties only. And that was a big argument that the banks were making. Well, in February of this year, so the current Q1 that just closed, the OCC issued a final rule clarifying that national trust charters allow for more than just fiduciary activities. And this, a lot of people didn't notice this, but ultimately this was a big point for the crypto industry, because it allowed them to continue with these trust charter applications with the knowledge and with the guidance and affirmative affirmation from the OCC that yes, a trust charter allows you to do more than just play a fiduciary role. That point goes to crypto. I think the next point maybe goes to the banks, and that relates to deposit insurance. So another fight that's been going on is, does a stable coin have deposit insurance? And so far, the answer is going to be no. In the recently closed Q1, we had a speech by a federal banking official, as well as language in some of the proposed Genius Act rules that indicated that federal deposit insurance would not apply to stable coins. And so there's one point for the banks. And so that is an issue that is still being very hotly fought out and debated right now, both in Congress as well as in the comment process for the OCC proposed rule. So that fight's not over, but the banks did win kind of the first battle there.
I think one of the important things that came out was you had a community bankers association start to raise some raise some flag. For every dollar that came into the bank, $2.77 of it went out to a stable coin provider of some sort. Rob, what were your thoughts when you saw that come across and them talking about the flight? Is this fear mongering? Is this like the reality? And do you agree with my position that this is just something they're going to have to figure out?
I think the reality is nobody knows exactly how the market is going to react once Genius goes into effect and once stablecoins are more broadly issued. My advice has always been that it doesn't have to be either or. And I do think in the future, we're going to see the traditional financial sector and the crypto sector converge more and more and more. A traditional bank should be asking themselves, how am I going to integrate stablecoins or other crypto? And then similarly, crypto natives should be asking themselves, how do I better access or allow access to the traditional financial system? And I think that is the future, if not the present. And that shows that retail bank account holders are opening accounts at crypto exchanges as well. People will typically, I think in the future, most people will have an account at a crypto exchange or similar company. And the study found that. That's the one that scares the banks, is that they saw that for every dollar coming in from an exchange to the bank account, $2.77 left the bank going to the crypto exchange account. And the worry, I think, on their part is once Genius goes into effect, that $2.70 may double, triple. So we just don't know. But that's the nature of the debate. And that is part of where the rubber hits the road in terms of the ongoing sort of fight between the banking sector and the crypto sector. And it sort of arises or materializes in some of the details of the Genius Act proposed rules, especially things like the yield debate, but also other areas as well.
The core argument that we're hearing from these banking associations is that there are non-banks that are issuing bank-like products without a full bank regulation, and that it's unfair. It's unlevel. The playing field is shifted out of their favor, and they're really trying to figure out how to get engaged with that same group. Honestly, the fight over, and you mentioned earlier, the fight over the stablecoin yield seems like the one that was focused on the most in the first quarter of this year, especially for people outside of Washington. Why do you think that this question of should they, shouldn't they offer a yield matters so much at this point?
My personal view is that when Genius was initially being drafted and envisioned, the stablecoin would be a payment instrument. So it would be sort of the modern day equivalent of an ACH. What we've realized now in going through the process of bringing Genius to get signed into law, now everyone has realized that there is a market demand to use stablecoins not just as a payment instrument, but actually as a store of value, a place to hold your money. Mm-hmm. And I think that maybe surprised some folks who were working on the legislation. And that I think is a driver of this issue. It's partially a consumer protection issue because some would say that the stablecoin is not intended to be a store of value, and that's why there's no deposit insurance. Well, the counter argument to that is, well, why don't you let deposit insurance flow through to stablecoins? So that's the counter. And then, there's even a counter to that, which is, well, maybe those businesses will actually get the right to issue interest and also the right to have deposit insurance by becoming a full national bank. And that may be another area where some of this is headed.
It's still unresolved, but it is going to be one of the most commercially consequential debates that we have around Genius Act rules. And as they're being defined and as all these things are coming into play, I think that's going to be the space where there's a lot of debate and there's going to be a lot of pushback from both sides.
Yeah, the economics will drive a lot of it too. The crypto native company is in position to provide that yield. That's hard to ignore from a market perspective. And then of course, the counter argument is, the consumer protection piece. So this conversation and this battle will be continued throughout 2026, in my view.
The idea around this is it's not a theory anymore. I mean, Wyoming has Front live on Kraken. We've got SoFi with SoFi USD. Looking at those two seemingly different types of accounts, what does that tell you about the direction of where things are going? And what I think really makes this interesting, and I'm probably going down a rabbit hole on this one, is the fact that Kraken got a Fed account with their Wyoming charter. What is this telling us, Rob? It's slightly confusing.
You make a really good point in bringing up the Wyoming Front stablecoin and then the SoFi stablecoin as two great examples. But most of them, by and large, are sort of reserves held by a U.S. bank, audited by a public accounting firm. The issuer itself, trust charter application with OCC pending or already has one granted. Then you've got Wyoming's Front coin, which is very much different because this is a state-issued stablecoin issued in partnership with a major U.S. crypto exchange. So that's a little bit of a different model, very different model. SoFi's, the SoFi USD stablecoin is also very different. On first glance, maybe it looks the same as some of the other stablecoins in the market. The big difference is SoFi is not operating under a trust charter. SoFi is operating under a full national bank charter. And so they are the first full national bank to issue their own stablecoins. And if SoFi can do it, why not any major national bank?
That's the piece that I took away the most out of that, is like the idea around this is like, hey, we're not going to worry about if the deposits go to stables because we're going to issue our own. We are going to build an ecosystem that allows this to happen, that allows us to do this and allows us to deliver this to our customers the way that they need. And I think that's a big difference from a lot of the other players that maybe were mentioned in those 98 community banks. Now, mind you, I'm very aware that not every bank has the technology, the staff, or the expertise to do what SoFi has done. They are a technology-first bank, so that does change it, but it is a real-world use case, and it shows that by both a state government, a traditionally nationally chartered bank being able to launch these products, that the pathway already exists if you decide to go down that path as a financial institution or as an organization in general, that it is possible in there that you can make it happen.
The stablecoin market is splintering, and there will be stablecoins that are targeted at specific segments of both the U.S. and global populations. And so it's not going to be one size fits all. It will be some stablecoins are better for certain use cases, better for certain market participants. Others are better for other participants, whether that's institutional versus retail or different markets within the institutional space or the retail space or a combination. And I think we're absolutely starting to see that already.
I'm glad you went there, because while we have all these regulators are writing the rule book as we go for stable coins. I mean, the SEC was doing something just as important on the security side of it. And it finally told us and the rest of the market what kind of crypto assets it thinks exist. And I want to start with the biggest picture of this, right? On the 17th of March, the SEC published, and I got to read this. It is release number 33-11412. And it really dove into giving us 5 separate categories for what a crypto asset actually is. So I'm going to go ahead and have that put up on the screen. Walk us through what these 5 categories for what a crypto actually is for us, Rob.
So first, digital collectibles. Digital collectibles are not securities. These are crypto assets come to known as NFTs and meme coins. So these are digital collectibles, not securities. The next category, also fairly straightforward, digital tools, not securities. These are crypto assets that perform a practical function such as a membership, a ticket, a credential, a title instrument, or an identity badge. And these are more emerging use cases for crypto assets, but still use cases that I think most people are relatively familiar with, using the digital asset as an access device or credential or identity credential.
I mean, I've even used a digital asset to do that, to get into an event. They authenticated it. I think that's really cool. And I'm glad to see that they put that in here where it is not a security.
Yeah, and it's a use case for blockchain that I think gets overlooked a lot. That is one of the basic use cases of authenticating a transaction on a network where everyone trusts the information on that network. So those are digital tools, not securities. The next category, stablecoins, specifically a Genius Act stablecoin. We just spent all this time talking about the Genius Act. So a stablecoin that is issued and regulated under the Genius Act is not a security. So that's great to have that clarity. And then the fourth category, also relatively straightforward, digital securities or tokenized securities. Guess what? Those are securities. In other words, if it's a crypto iteration of a traditional security, something that is enumerated in the definition of the term security, and it is just a crypto asset version of that, then it is a security. So a security is a security whether or not you put it on a blockchain or not. So I think that those are all pretty straightforward, those first 4.
I do want to, as I'm looking at the document that the SEC sent out, there's a section where it calls digital commodities. They gave examples. It says examples of digital commodities include Aptos, Avalanche, Bitcoin, Bitcoin Cash, Cardano, Chainlink, Dogecoin, Ether, Hedra, Litecoin, Polkadot, Shiba Inu, Solana, Stellar, Tezos, and XRP are the ones that are listed in this. This is nuts. Like a lot of people would have thought fell into securities because there's so much being done around and with them. So I thought that was really interesting that they brought those up.
The fifth category, digital commodities. Digital commodities are not securities under the SEC interpretation. Here's the definition. Crypto assets that are intrinsically linked to and derive value from the programmatic operation of a crypto system that is, quote, functional, as well as supply and demand dynamics, rather than from the expectation of profits from the essential managerial efforts of others. And we can unpack that, but there is a specific list in the SEC interpretation of what is it? It's like about 15 or so specific crypto assets.
There were 16 counted out specifically as examples. The footnote adds Algo and LBC onto that as well. So we got 18 that have been added to this. But I want to get to the part that made everybody kind of go, what? At least for me, right? Like the as I was reading through a lot of this, is the idea that a token in of itself can detach itself from an investment contract. I would love for you to tell the Orange Grove story the way you do for your clients to help them understand this detachment.
I think the easiest way to explain this is actually to go back to a recent speech by Chairman Atkins, where he actually addressed this. And he asked this question: how can a non-security crypto asset separate from an investment contract? And he said, the simple yet profound answer is that the issuer of the investment contract either fulfills the representations or promises, or fails to satisfy them, or they otherwise terminate. In other words, the investment contract ends, but there is still this piece of property that continues to exist. And we can think about things like, for example, Ether. You go back to the original pre-sale for Ether, and that pre-sale event had investment contract type qualities. But now, fast forward since the Ethereum network was launched, Ether no longer is really tied to those investment contract type arrangements. And it's a digital commodity, an asset in and of itself.
Most likely, consult with your attorney, but most likely will not be a security once that happens. Is that an accurate way to look at it, Rob?
So a digital commodity typically conveys to holders certain technical rights with respect to the associated functional crypto systems. So as an example, a digital commodity can enable holders to participate in the system's consensus mechanism by staking or locking up that system's native digital commodity. It can act as a governance token, which allows holders to vote on certain technical or governance matters, such as software upgrades.
There's one key sentence that is saying a digital commodity does not give you passive yield or rights to future income.
Yes, that's it.
And that feels like the line where some DeFi tokens still are going to have some serious problems. I don't think we're ever going to get away from some of these folks wanting to do this, but I think that's where we're going to start to see the issue shift over to.
Agreed. Yeah, and at least it's clarity, right? It's a bright line. A digital commodity does not have intrinsic economic properties or rights, such as generating a passive yield or conveying rights to future income, and it goes on from there. But that's a bright line. If it has those characteristics, it's probably very likely fits more to the security category.
One of the first ones that popped out and was really used in an example of this is a security. Sorry, you guys couldn't see my air quotes. Really was the Munchee token in 2018. And that's what they used. And then Meg Prime in January of 2026, they got a no action relief on something functionally extremely similar. So Rob, I'm not an attorney. I don't understand what the heck happened here. How do both of these things that exist seemingly in the same universe?
Yeah, the Munchee case. I mean, attorneys like myself have been practicing this space for a long time. We all remember the Munchee case. This was the very first highly publicized enforcement action by the SEC, where the SEC obtained there was an initial coin offering being done by a company called Munchee. And the SEC came in and issued a cease and desist, and that ICO never happened. And fast forward, and we have Meg Prime, which was the subject of a recent SEC no action letter. And to your point, Ted, it's not exactly the same as Munchee, but it's pretty similar. One of the concepts of Meg Prime is that it's this token that is earned through activity conducted by the retail holder. And then that retail holder can spend that token in exchange for various like basic consumer items. A lot of similarities to Munchee. The big difference in Meg Prime, this was a functional system. And so this gets to this concept of a functional network, which goes back to a key term from the recent SEC interpretation.
Support provided by Skyflow. What if you could build fast but not break privacy? What if you could ensure data privacy, governance, and compliance with just a few API calls? What if you could worry less about PCI requirements while actually improving privacy and security? How much more time would your team have to truly innovate? How much faster could you build and ship new features? How much more powerful could your app be? Skyflow is a zero-trust data privacy vault delivered as an API. Skyflow's radically simple design lets you collect, secure, and tokenize personal information like card data and payment details. And with built-in features like encrypted data analysis and sharing, anonymization, and advanced governance, your days of choosing between data security and data usability are over. Whether you're just concerned with PCI compliance or need to go further to include CCPA, GDPR, SOC 2, and beyond, Skyflow has you covered. What if you could build fast but not break privacy? With Skyflow, you can. Visit skyflowsecure.com today to learn how. So welcome back. We had to take a quick break for our sponsor, but Rob and I are back to finish out talking about the rest of the things that happened in the first quarter of 2026. So Rob, we left talking about the guidance and what was going on, but I want you really to help us understand. We've seen Chairman Atkins basically, and I think you and I could agree on this, announce what his moves are going to be. And then after he announces them, he delivers directly on it. What do you think he has previewed next, and why should people really care?
If you're paying close enough attention, really, it's no secret. And it's been great for the industry. Chairman Atkins has really, at this point, established a track record of doing everything that he says he's going to do. As an example, the guidance that we just finished talking about that provides 5 different categories of crypto assets. Chairman Atkins previewed all of that at ETH Denver back in February. And he gave a speech where he outlined those categories. And sure enough, when the SEC interpretation was published recently, it's the exact same 5 categories that he talked about in his earlier speech. He's done this enough that, in my view, it really is becoming quite reliable. And most recently, he has indicated in a speech in March that this interpretation that was recently published is just the beginning, not the end. And the next move is for the SEC to publish up to 3 different safe harbor proposals targeted crypto assets. They'll called Regulation CA standing for crypto assets. And it's 3 different proposals. We can kind of get into the details. But again, this was previewed just about a month ago.
If we look at the timelines of some of these things, right, the pace at which they're happening continues to increase. Chairman Atkins had mentioned being very clear and bringing out the guidance. He talks about the next thing he's going to do, because the speed that he is delivering on his perspectives and the things that he's doing to try and guide the industry it's at a breakneck pace.
I agree. I mean, we've never seen anything like this. The SEC Crypto Asset Task Force is moving at lightning speed. To your point, I would not be surprised if by the time this podcast is published, we have a proposed regulation with one of these exemptions that Chairman Atkins mentioned back in March. If we don't have it by the time this podcast is published, I think we will certainly have at least one by the time we do the Q2 podcast. So it will be interesting to see what comes first and how much progress is made, over the next 3 months.
Without going into a lot of details, can you quickly outline the 3 papers that you mentioned? Like, what are they called? What are they for? Let's not go into the technical details. Let's just give everybody kind of an overview of what they should be looking at and what it's about.
The goal of all this, paraphrasing the words of Chairman Atkins in his speech, is to provide crypto innovators pathways to raise capital in the U.S. while providing appropriate investor protections at the same time. So that's the overall goal. And to meet that goal, there's Chairman Atkins discussed 3 potential exemptions that could be issued. The first he called a startup exemption, and that would be limited time duration exemption from registering under the SEC's rules that would be designed to enable developers of crypto asset projects to, quote, work toward maturity of the project and permit entrepreneurs to raise up to a certain amount of capital. So it would be like a capped amount of fundraising without having to register with the SEC or with having some sort of limited registration requirement. The next would be a fundraising exemption. And that would apply, we talked about this concept of an investment contract that's tied to a crypto asset. Well, there would be a fundraising exemption that would apply to exactly that type of asset that would allow us, again, a certain amount of capital to be raised while that investment contract is sort of tied to the crypto asset. And then the third, he termed it an investment contract safe harbor. And this would exempt investment contracts from the definition of a security for some crypto assets after the issuer has permanently ended all the essential managerial efforts, which, as we discussed, is a key part of the Howey test. Again, intended to just help facilitate fundraising while still maintaining appropriate investor protections.
Rob, thank you for that guidance and that understanding. We're going to be putting links to a lot of this stuff in the show notes. So if you're curious about the things that we're talking about, all that stuff, go ahead and check out the show notes. We'll get into that deeply. But Rob, I want to move on into, we just talked about the SEC gave the market a map for the Q1. It looks like it's rolling into Q2 as you just talked about. And I think it's really good when you start to look at applying these to good actors. And it works really, really well as long as they play by the rules. But as you and I both know, not everybody plays by the rules. So the other big story I think happened in the first quarter is when stablecoins are becoming mainstream, guess what happens? They start to become that preferred tool for these illicit activities at the exact same time, just like cash. I mean, that's the number one use for these illicit activities. Number two, I don't know if it's true, but I have a feeling we're sliding towards where stables may become the number two for this type of stuff. Beside that, I do want to kind of give a stat out for everybody. 84% of all illicit crypto transactions in 2025 were stable coins. Do you remember where that came from, and what should we take away from that number?
So that stat was published in a report by the FATF, the Financial Action Task Force, the stat itself was published in the FATF report, but the stat comes from a Chainalysis. And my understanding is that Chainalysis has a relationship with FATF and sometimes participates in their meetings and, has sort of some level of information sharing with FATF. And so it's not surprising, but, Chainalysis is one of the primary, most trusted sources of on-chain data analytics. And so, when you get a stat like that coming from Chainalysis, I find it to be an interesting stat because up until now, Bitcoin has by and large always been the preferred crypto for illicit activity. You can speculate as to why that might be. My personal view is because it's got a lot of liquidity. It's the most popular crypto, so it's easy to find someone to exchange it for you. It's a trusted network. It's arguably the most trusted network. So, criminals want stability in their value and value transfer, just like anyone else, right?
That's a good point. That transition from something that's a lot more volatile, like a Bitcoin or any of the other meme coins that we would want to mention. We mentioned earlier, we gave a list of 16, 17, 18 items that are looked at. I'll call it utility purposes for payment transactions. As you talk about this, I didn't think about the stability piece of it. Liquidity makes a little bit more sense to me, but the stability of that is, and unless you're a hodler, like the stability is going to be a big deal. When we look at this, what percentage of these stablecoin flows have they found are through these, I'll call them professional money laundering services? Like what does that look like?
TRM Labs published a report finding that over 70% of illicit stablecoin volume flows through less than 100 what they call professional money laundering services. And so what that tells us is that, I think there's a lot of analysis you can put into that stat. One takeaway It tells us that ecosystem around illicit stablecoin activity seems to be relatively small. Usually it's going to be a good thing for the good guys because that means there's a small attack vector, right?
I have to ask, you say it's small. These numbers don't seem small. Why do you say small?
Small in comparison to like the global financial system. You look at the traditional financial system as an analogy, there are still hundreds of millions of dollars that are laundered through the traditional financial system every year. It's a cat and mouse game. Banks have their compliance departments and their AML staff trying to catch these things and report them. And then law enforcement tries to take action based on those reports. And despite all that, there's still hundreds of millions laundered through the traditional banking sector every year. And if you think about like the global financial system, how many banks are there that mostly unknowingly, are facilitating this? It's definitely, I don't know how many it is, but it's a lot more than 100.
The consequences of all this illicit activity, at least one of them, is this is putting a lot more pressure on the issuers to act like a financial institution when fraud or any sort of criminal use shows up. And I think it's important to note that the DOJ seized about $61 million in USDT this quarter with the support of the issuer. Now, I feel like this does kind of feed the debate around freezing it, then burning it, and then reissuing it. Do you feel the same way? And if so, why? And if not, why not?
Well, I think that you are getting at a topic that will be a subject of very intense debate in the future, like in the immediate term future. What level of monitoring does a stablecoin issue have to perform to prevent illicit activity? For example, someone who's coming to a Genius Act stablecoin issuer and saying, hey, I want to redeem my stablecoins. I'm going to send you my stablecoins. You send me the cash, right? The stablecoin issuer obviously has to do diligence on that party. If there's ever an illicit activity involved, it's not going to be through that primary party. It'll be 1, 2, 3 more hops down the line. And so the question is, how much diligence does that issuer have to do? How far do they have to go? How far do they have to trace that stablecoin to try to detect potential illicit activity? That's an open question that I think most folks are not really thinking about now that we're going to have to grapple with. And then the second, which I think is coming more immediate, is the one you pointed out, which is to what degree should a stablecoin issuer, either under Genius Act or otherwise, have the responsibility to freeze stablecoins that are involved in illicit activity, and then to take it a step further, not only freeze them, but burn them and reissue them. I think that's an issue that is going to be hotly debated in the next 6 to 12 months.
What we're talking about here is a permanent freeze on those assets. Then when it's identified as being criminal activity, it gets completely burnt. Think gas fees, it gets burnt completely out. And then this is what blows my mind. Then what has to happen is that the same amount of tokens that were burnt now have to be reissued just so that it can get back into the system. I think that's interesting that the thought process is to go that route. Am I thinking about this wrong?
A third option is actually to just for the stablecoin issuers, simply issue the US dollars cash. I'm sure that the issuers have a preferred method. However, I think from the victim's perspective, probably doesn't matter all that much. I think the larger question is, should they be required to do this? If they are required, what does it compel an issuer to freeze and then reissue stablecoins? Do you need a court order? Do you need sufficient evidence that the stablecoins have been used for illicit activity? And who gets to decide if it's sufficient? Is it the issuer? Is it someone else? Or again, do you just kind of rely on a court and say if you can get a court order?
That's actually a good point too. Yeah.
And I think all this is yet to be decided. And I think these will all be topics that we'll be debating over the next 12 months or so. And even more so as Genius goes into effect. And also even on top of that, even more so as stablecoins begin to be seen by the bad guys as a good way to store and move launder money.
And so you start to think about all these different things, the US regulations and there are a lot of people who are like, fantastic. So I'll just go offshore and avoid all of this fun stuff. But guess what? FATF has started to take aim at the offshore companies. They have really started, and in the report, they really kind of talk through what this means for this, like the registration and jurisdictions. And if you're a US person using an offshore stablecoin provider, what is that? What does all of this mean for you?
Similar to some of the concepts that we talked about earlier, you know, in terms of the stablecoin market splintering in different directions and different stablecoins being used for different purposes. On the one hand, Genius Act regulated stablecoins by a US issuer. And then on the other hand, stablecoins not regulated by Genius that are intended to be used offshore, to the extent that a US person chooses for whatever reason to use not regulated by Genius, by foreign issuer. But the message is from FATF is that FATF is looking for foreign-based stablecoin issuers and other VASPs to start catching up, you know, to the level of anti-money laundering regulation that we have here in the US. You know, if the reason why someone is using a foreign-based stablecoin has something to do with the lax AML controls, well, that's not going to be the case forever. How quickly will that gap close? That's another question. Certainly hasn't closed as quickly as FATF would like, but the pressure is there, and I do think that's the direction things are headed.
If you are looking to figure out a way to arbitrage the regulatory environment, it's going to continue to get harder and harder and harder, especially as we're starting to see these jurisdictions coordinate with each other better and better over time. So that as that improves, it's going to be harder and harder, is not going to be as advantageous. Zoom out a little bit, right? So North Korea, other organized actors are using like an industrialized system. This, I believe, has the regulators thinking about the whole market completely different. I think that's also where some of the coordination comes into play. How much do you think that this is impacting the way the regulators are looking at the global market?
I think it's a key driver, absolutely, especially the activities that we're seeing undertaken by DPRK, which is an arm of the North Korean government. At this point, they really have got, the North Korean government really has three main sort of, to your point, industrial complexes by which to steal crypto value from the US and other countries. The first is just straight up hacks. That's been going on for a long time. The second that now is becoming equally as dangerous as hacks is where they were reaching out to individuals and trying to trick them into investing in, you know, fraud schemes essentially, and sending their crypto, you know, to where it's in the hands of ultimately North Korea. So that's the second, pig butchering. And now the third, which is actually becoming more of a concern for legitimate businesses, is these remote IT worker schemes where you've got a shell business that reaches out and says, hey, we offer remote IT services. And they say, but hey, we because of, you know, wire transfers are expensive and stuff, you have to pay us in stablecoin. So now you're paying in stablecoin. It's going directly to the benefit of the North Korean government. It's not easy to catch because it's crypto, so it's not going through the bank system. So it's not going through an AML program at a bank. And so that third one is actually the most dangerous for legitimate US businesses that if they haven't heard about these schemes and don't have take steps to uncover them, could unknowingly be, you know, making payments to IT workers that are ultimately working for North Korea.
It's a totally different ballgame when you start talking about national security and all these different pieces and state-sponsored actors. I mean, it's so different than the con artist, pig butchering perspective, like the hacking to get in, to steal the crypto. Like it gets really crazy really fast. There are new ways that are being brought to our attention. And so that's why we hear more about it. At least that's my opinion of that.
I'm glad you brought that up, Ted, and I agree with you 100%. And it's a really important point to bring up anytime we talk about this stuff, because none of what we've just discussed is any reason to be anti-crypto. You know, to your point, I mean, the vast amount of money laundering, as we discussed earlier, happens through the traditional banking system. The vast amount of money laundering happens using cash. Cash is still king, but we're not looking at, you know, outlaw banks or outlaw cash, right? So Same thing. It's just a new way of value transfer. Of course, it's going to be used for illicit purposes sometimes, and we need to try to prevent that. But it's no reason to be against the technology itself.
We've got a real stablecoin rulebook that's being built. It's in progress. We're seeing it happen. We saw the SEC draw lines around what crypto asset types are and how to look at them. We're seeing lots of AML pressure building extremely fast. What do we need to be watching in the second quarter? Like, my first thing is, will the OCC's reserve asset restrictions that they've put in place really survive the industry pushback from both sides? I think that's a piece that I think we're going to see a lot of movement around. There's going to be progress and there's going to be all this stuff, but we've got major items that have gone out for comment that are going to come in Q2. Rob, what are you seeing with that piece of it?
Personal prediction is I think that it will remain as proposed. I think that it's a conservative set of restrictions, and I think that is intended to build trust in an emerging stablecoin market. And I think there are a lot of stakeholders who many might want to expand upon that list of reserve assets. I think most people understand the launch of Genius is going to be a critical period where we need to build trust for consumers. And so it makes sense to take that conservative approach. And that list of reserve assets can expand over time. My personal prediction, while there probably will be a lot of comment and back and forth and debate, I think we'll end up where we're at right now with the conservative list.
I think the places to watch are going to be the stablecoin issuers that have a lot to lose if it gets too strict. And then you have the financial institutions and banking associations are going to be fighting over trying to do the best they can to make it fit within the financial institution box. It's going to be a lot of fun to watch the comments going back and forth. And so it's super important to also keep in mind is that all of these comments are publicly available, right? So you don't have to wait till after the fact. You don't have to. All of these comments as they come in are publicly available. You can keep up with that. And then the last thing that I start to look at, the acting comptroller, he's made a comment. He wants to keep it strict. He wants to make it so that we don't kill innovation. So his final rule on this could tilt us either direction on that piece of it. The other piece, I think we need to keep our eye on the stablecoin yield fight, where it lands, how it lands. Does it stay within the rulemaking? Does it start to get political? I think we're going to see a lot of those things. Where are your thoughts on this piece specifically? When does it get resolved? Is it Q2 or is it later?
I do not think it will be Q2. So it's another great opportunity to try to make a prediction. And it's anybody's guess, right? My personal prediction is I think this debate will continue through Q2. It doesn't have to be finalized until the OCC issues the final rules implementing Genius. And I do think the OCC is most likely looking to issue those final rules and implement Genius by the fall. My understanding is that if they don't, the Genius will take effect of its own accord through the language in the actual law sometime shortly after the new year. But I think OCC is looking to enact it sooner. But I do not think the final rule will be published in Q2. And that means as long as that final rule is not published, there is still room to debate. And I think because there's so many perspectives from so many that debate is going to rage on up until the point when the final rule is published. And it's, at that point, the rules are set until Congress or OCC tries to change them through additional laws or rulemaking.
If you look at the OCC's proposed rules, the language that's in there really directly targets specific revenue arrangements that have been put in the marketplace. Those who pay yield on behalf of stablecoin issuers, if that language survives, it will eliminate a large source of revenue for players in the marketplace, many players in the marketplace. And I think that's a piece that is something we should be watching really closely. Not only that, but looking at all the different bank side arguments. If you look at the letters of comment that have come in from these associations, like they want a strict reserve interpretation, no creative workarounds, nothing. It's like it's a 1-to-1 ratio, no variation, like all these different things in there. I don't believe it's going to be that strict, but that's another area I think we should be watching really, really closely for.
We're still in the thick of these debates, and they could go in a lot of different directions. And even when they're resolved initially, they're still really not going to be over because, for example, let's say the yield debate ends with the way that we have a language in the proposed rule where a related third party, related to the issuer cannot offer yield. Well, that's still not the end, frankly, because what if that third party then gets a national bank charter? Can you pay yield and just call it interest on a deposit, just like any bank, right? So that's just one example. And there will be other ways the crypto industry, tries to get to where it wants to be from a market perspective.
We should be paying attention to is how the safe harbor drops in the next few weeks, the changes that happen. What are you looking for? What are you watching when it comes to that safe harbor stuff coming into Q2?
It'll start in the form of a proposed rule. So a proposed rule is just a proposal. It's not a regulation. So it has no force of law. It's a discussion draft. A crypto asset exemption from the SEC that's in the form of a proposed rule. That doesn't mean you can go ahead and start following that proposed rule and relying on it because it hasn't been finalized yet. So there will still be that public comment period, just like we're going through with Genius right now, where there'll be a comment period where people can propose changes, revisions. And for that reason, it's something to absolutely watch, and absolutely you can sort of prepare for when that proposed language becomes final. You won't be able to rely on it, immediately upon publication. So we'll still have that interpretive guidance, and that will still be sort of the main piece of guidance to look to from a regulatory guidance perspective.
So the next one is really the Clarity Act. I've been very open to say I don't think the Clarity Act is going to make a whole lot of movement this year. I think it's going to be more of a discussion point than an actuality. Do you see real movement, or are you seeing more delays as I'm predicting?
I think I ultimately have to side with you on this one in terms of predictions. I do not think we'll have significant developments by end of Q2. I do think that there will be a push in Q2. Will that push be successful? If I have to guess, I'm going to say, unfortunately, no. Then we'll have the summer recess. And then I think there'll be another real strong push in the fall to try to get market structure legislation passed before Thanksgiving, essentially. And that will be the last final big push to see if it can happen this year.
I'm going to be paying attention to the most is watching that Senate Banking Committee, looking at their schedule, what their publishing schedule is. I'll give you an example. Right now, they have no calendar notice on when it's going to be published or what's going on, which means, in my personal opinion, is there's not going to be any markups going to be happening before they get back from their summer recess, right? So there's going to be a lot of speculation beforehand as it starts to roll when they come back. There are 3 sticking points that I'm paying attention to as well. Sufficient decentralization for the SEC and CFTC jurisdiction. That's when I'm going to be paying attention to. How they treat DeFi governance and token holders. That's another one that I'm going to be paying a lot of attention to. And then the scope of the developer in safe harbor for open source protocol builders. I think those are the 3 that I'm going to be really diving into and really paying attention to. That's the places that I think I'm going to spend the time. And I think as we see the Genius Act implementation rule advance, there are a lot of people that are saying, let's see how these rules work before we legislate. I don't think we're going to wait for that. So I'm watching for how they're going to frame that up so that it can continue to move forward. So that's the biggest piece for me.
One of the pieces that you discussed that I find very interesting is this concept of whether the word decentralization and that concept will actually make it into law. As you can see, as we talked about earlier in the SEC interpretation, that word was not really present. It was in 3 footnotes. But ultimately, the SEC used more sort of plain English descriptions to substitute for that term. I tend to like that approach. It's more understandable. Ever since this word decentralization was introduced, it's just caused a lot of confusion. It's really hard to pin down what it actually means. To me, it will be interesting to see if the language from the SEC interpretation makes it into, the Clarity Act market structure language, or will the term decentralization remain? I also agree with you that you make a good point that some of the less sophisticated stakeholders might make an argument that, why do we have to make a push for the clarity and market structure bills? We have Genius now. Let's see what happens when Genius goes into effect, and then let's decide. A more sophisticated understanding of the crypto market shows that these are two completely unrelated things. Ultimately, seeing how Genius unfolds really is not going to help in predicting how the Clarity Act or market structure legislation will unfold in practice. And so I would hope that sort of the clearer, more sophisticated viewpoint prevails. Genius is not used as an excuse to delay Clarity Act and market structure. But we'll see what happens.
Yeah, those are a lot of things to pay attention to coming into Q2. Most of it probably will not become reality, but keeping track of it during the process really helps you understand why it ended up the way that it did. So we'll be happy to keep you guys all in touch with what's going on in that space. Rob, I've got one last one for this episode. You know me, I like to ask the so what question. If you had to give builders and operators in the digital asset space one sentence of advice heading into Q2, what would it be?
I would say bring stablecoins into your strategy and make it a stablecoin that is intended to be regulated under Genius, because that is your long-term best bet right now in terms of what the future will hold.
If you were to give 3 concrete actions from where you sit and all the things that you see, what would they be? They should be really just taking action on.
Find a way to integrate stablecoins and make it a stablecoin that is intended to be regulated under Genius, not a different type of stablecoin. That's number one. Number two is, to the extent that you are looking to launch or have already launched a crypto project that involves your own crypto asset, you need to look at that SEC interpretation very closely and find a good lawyer that can help you interpret it. And you need to use that as your guide as you build out your strategy. And then the third is take anti-money laundering and financial crime seriously, whether or not you are required to have an AML program. If you're required, you absolutely should take it very seriously. But even if you're not, you should still have a plan for how you're going to make sure that your business is not used or does not touch illicit activity, because that's just good business.
So, Rob, I'm going to get a little bit more tactical on this piece. I think they need to read the OCC comments before the period closes. I think they need to get and understand what their transition window looks like for how they're going to implement the Genius Act. There's only an 18-month window for that thing, so we really need to figure that out. Lastly, they need to track the safe harbor proposed rule and treat it as if it's coming in. So those are the big pieces that I see happening in there. Rob, I don't know if we should tease this or not, but I think we're at a point where we may need to do a full episode just diving into the details of the dedicated SEC guidance and really get into what that means. So if y'all want to hear that, let us know. We'll go ahead and get that staged up for you. But Rob, thank you so much for spending time coming back to finish the episode. I know we had a lot of fun this time, so thanks again, man.
Thanks, Ted. It's always a pleasure to be on the show. I always have a lot of fun. And so thanks again. Look forward to coming back.
So, folks, that does it for another episode of Fintech Confidential's Web3 with FTC series. If this discussion about Web3 got your attention today, that's perfect, because that's what we have you coming here for. And if you want to hear more, go ahead and head over to YouTube, Spotify, Apple Podcasts, or wherever you listen. Hit that follow button to have it delivered to you. If you want to stay really plugged into everything we got going on over here in and outside of Web3, head over to fintechconfidential.com and sign up. This is where we have all the deep dives, all the extra information, all that is there. And if you think someone would benefit from this and they're serious about where fintech is going, be sure to share it with them. And as always, keep moving forward.
As we wrap up today's episode, I've got one last thing for you. If you're in the trenches fighting fraud and financial crime, you know it's a complex battlefield. That's where Hawk's AI tools for real-time payment screening, AML, transaction monitoring, and dynamic customer risk rating come into play. These aren't just buzzwords, they're game changers designed to make your compliance more effective and less of a headache. Imagine slashing through false positives with precision and giving your compliance strategy the edge it needs. Head on over to gethawkai.com to sign up for a demo and discover how their platform can revolutionize how you fight fraud and financial crime.
This has been a production of DD3 Media, with all rights reserved. This is provided for informational purposes only. It is not offered or intended to be used as legal, tax, investment, financial, or other advice. We strive to provide accurate and up-to-date information, but will not be responsible for any missing facts or inaccurate information. You comply and understand that you should use any of this information at your own risk. Cryptocurrencies are highly volatile financial assets, so research and make your own financial decisions.